morning, everyone. First, first of all, I would like to thank for the started from organizing this event for the request part of today presentation. So, DML product in 2000 started in market, so got 24 years in the relationship. So, DML based in architecturally including for academic doers and credit commercial panel, e-com. So now,
from ordinary to extraordinary, from small dream to big achievement. In Malaysia, there's an abundance of aluminum materials. Many buildings have exterior walls crafted from aluminum, giving them a sleek and modern design. We are DML. DML is a composite panel, and we provide 3 types of panel, which is PE, FR, and A2 panels. We provide PPPF finishing in a lot of colors choices. We can customize length to avoid or reduce the wastage. DML is the optimal choice for facade, as it enhances the overall design aesthetic. DML water panels also come with fire safety certifications, all of which are test certified from Serum and Bond. Moreover, our A2 panel can resist fire up to 2 hours, thus preventing fire propagations. It also suppresses smoke. Our ACP is flexible, customizable, and reduces sound transmission by up to 30 decibels. EasyBond is another series of DML designed for cost-conscious users. It can be used for doors, cabinets, signage, and awning panels, and offers a variety of textures. Our panel is anti-rusty, rigid and flexible, and a lot of colors choices, weather and UV resistant, anti-termite fungi resistant, and we provide a 10 years warranty. Our panels is fireproof and safe. As we conclude this journey, we invite you to take a glimpse into the world of possibilities with us. Our collection of stunning projects showcases the artistry and innovation that define our brand. From architectural marvels to captivating interiors, each project is a testament to the endless potential of the DML. We hope these images inspire you as they have inspired us. If you're ready to turn your design visions into reality, we are here to support your every step. Today, we are proud to unveil our latest collection of DML aluminum composite panels, designed to inspire and elevate your architectural projects. Stay connected with DML for the latest updates.
After that, I will present this.
Thank you, Mr. Allen, for the welcome speech. Okay. So without further ado, I will continue with our first speaker for today, Yang Arif Dato' Anan Ponudurai, the distinguished judge of the Penang High Court. He was called to the Malaysian Bar in 1991. Dato' Anan quickly became a leading expert in employment, industrial and administrative law. He notably co-founded Bodicola Ponudurai de Silva in 2001, arguing many landmark cases. In 2019, he was appointed as Judicial Commissioner and then elevated to a High Court Judge in April 2022. Dato' Anan also contributed significantly as Chairman of the Kuala Lumpur Bar and the Malaysian Bar Council Industrial and Employment Law Committee, besides being a published author and arbitrator. Justice Dato' Anan will now delve into a compelling topic for today, architects see what again, offering crucial insight into legal risk in practice and lesson from experience. Please give a warm welcome to Yang Arif Dato' Anan.
I'm normally quite used to giving talks or speeches to a bunch of lawyers and judges. They're all more scary. Right? They'll ask you questions that I can't answer. Today, I hope to scare all of you. Alright? The topic, you're saying, I will scare you all into buying insurance later. I hope I don't scare you from leaving the profession altogether. Right, so anyway, thank you very much for the invitation today. I was asked to give a keynote address, not really a paper per se. So I googled it. What is actually a keynote address? A keynote address is defined as something that someone says at the beginning of an event, and it's designed to introduce the central theme of the event and to set the tone for the event. So that's what I'm hoping to do this morning. I must admit, the title is very catchy, right? Architects see the report again, as will become evident the rest of the morning. We will have back to report on this, right? Because we have a very rigorous society, and we looking to sue someone. I've got cases where they wrote everybody, developer, architect, engineer, everybody started to come and also they got that's the reality of it. Alright, so I've been asked actually to address the role of the architect in the legal and construction landscape. I must say, as I was growing up, a lot of people, some people today have this view that architects is a glamorous job. You sit down there, you design a beautiful building, and just have to do all that. I think we all realize that the architect's role today is really involved something very much different. I intend to address the role of architect quite clearly. Now, the architect today, I think, occupies a very unique position. One, not just his creativity, but what combines that creativity, control, and importantly, consequence. They're coming from a legal perspective, consequence of the actions and the role. This morning, I want to speak about that position. I will speak about design and documentation, about responsibility and risk, and finally, about dispute resolution, where I come in. Dispute resolution, which is a growing part of your work, whether you like it or not. Mostly here, you say I've done projects, I've never had a dispute resolution, I think you're doing something wrong. Dispute resolution will become a new thing. Now, architects, and you begin where others stop. You shape and design, but your drawings are not just artistic impressions. They are also very much legal and contractual documents. Firstly, under the Uniform Building Bylaws, you are the principal subject person, right? ESP, in short. Now, this sounds fancy, but this is not a ceremonial role. It is statutory. Not important. It's statutory, very, very important. It is a statutory role. It carries personal responsibility. You certify that those design complies with building laws, fire, safety, access, structure, ventilation, so much more. If your design is defective, your name is on record, no one else's. Then comes specification. Your specification is not a mere filler. It is not something to cut and paste. It binds contractors. It determines price. It defines quality. A vague specification invites variation. In cases of POs and variation. A loose specification invites abuse. Worse still, contradictions within the specification can lead them to defects and disputes. Under most building contracts, especially PAMs, you take two more roles. First, as contract administrator, you issue instructions, you assess delay, you determine entitlement. Secondly, you also as a certifier. You certify what is due, you decide when it is due, interim claims, practical completion, final account, all must pass through you. But here's the catch. Although appointed by the employer, the law expects you to be fair and independent. Certifiers are treated as having a quasi-judicial function. Quasi-judicial function basically means partly of a judicial nature. That means you must certify based on facts, not assumptions, not pressure from the Too many disputes begin with unclear certifications or late ones or inconsistent ones, please document what you become to court. It's always based on documents. People come and say ABC, you have the document back up, you don't believe it. So document what you do. Very important. If you are a person who can't keep documents well, keep minutes of meetings, keep minutes of discussions, take photos of the place, much easier. Recording on handphone, taking photos with handphone, it's much easier. Inspect the site, and above all, be consistent. Many times we see parties who are inconsistent. So must be consistent. Now, increasingly, architects face not only professional obligations, but also unfortunately statutory requirements. For example, under the Housing Development Act, HDA 1966, firstly, you must issue progress payment certifications unless the works are done. Unless you must not issue progress payment certifications unless the works are completed. 2. You must not certify for BP unless the full CCC in Form F, not partial CCC in Form F1, has been issued. Wrongful certification can now affect fines of 100,000 yen or imprisonment for 5 years. So bear that in mind. This is not theoretical. It is a real risk and it applies to all of you personally. If your project is certified, if your project is certified, the layers of responsibility increase. Firstly, you are required to certify superstructure completion, typically via Form 212, for strata level applications, so that the proposed strata plan can be surveyed and filed with the office or Japan. You are involved in preparing the schedule of parcels (SOP), including for completion blocks. You must ensure that approved buildings are submitted not just for the current phase, but for all phases, even those not yet launched, in order to comply with application requirements. So you can see your role is no longer confined to mere drawings or site inspections. It includes strict compliance with HDA, Strata Development Act, and of course Strata Development Act. These are all acts of parliament which you have to abide with and which have serious consequences. A further development is now the introduction of the Principal Construction Work Design, PCW, role under the Occupational Safety and Health Construction Work Design and Management Regulation 2024. Since the implementation on the 1st June, there has been industry pressure to treat architects as they reform PCW. Some architects are also involved in interior design groups. Others act as planning advisors. Some, in fact, manage the project. A few sit as expert determiners or arbitrators. Now, moving on to the topic, let me speak about disputes. Now, when conflict arises on site, who do parties turn to? I'm not talking really about the part range, but I'm talking really about the serious construction disputes. The architect. You are the first port of call. You know the facts. You have been there since day one. You've been there since day one. So you are the best person to actually avoid the dispute, the escalation of dispute. If you act early and clearly, that means architects respond to variation claims, clear records. They have to, when they give EOTs, granting or rejecting EOTs, these are EOTs, not granting or not, give reasons for granting or not granting. Call meetings, a lot of times, in the middle of a project, tensions very high. Call meetings, try to diffuse the tension, try to solve the problem at stage. Use the tools that are already available, such as mediation or expert determination, under the PAM contract, before lawyers get involved. I think increasingly you can see that lawyers are getting involved very early. It's not a bad thing, lawyers are not bad. But it can be, in my view, a lot of times it can be. Now, avoidance is not weakness, it is efficiency. Good architects avoid disputes by spotting them early, documenting them early, and acting early. I spoke to Sridhar shortly about use tools readily available in certification. Now, mediation today is a very important aspect of legal landscape. I think there's no dispute that there are too many cases in court. I think there are 20,000-30,000 cases filed every year. There only was 100 judges. Just cannot work with it. So the courts have turned to mediation as a very serious means to reduce workload. In fact, in some cases, like in writing down cases, there is compulsory mediation. Accident cases, there is compulsory mediation. Some jurisdictions have compulsory mediation before you file a claim, right? For example, insurance claims, the law in those countries mandate that they only file a claim once you've gone to mediation and receive a certification that mediation is failed. However, in this country, proposals to that have encountered serious objection, especially from the insurance industry players. They want to manage their liabilities, they want to have, because there are other issues. There's no civil claims, there are litigation periods, so these are all issues that we deal with. But the courts are seriously looking at mediation as a tool to reduce workload. As you know, the courtroom is not a place where most architects, quantity surveyors, engineers, or contractors ever imagined themselves when they chose that career. Nobody ever thought they were going to be a courtroom, right? Yet increasingly, these professionals are finding themselves having to navigate legal challenges ranging from design defects and delays to risk communication. And even negligence claims are included. Negligence claims, I'm sure there's a high number of negligence claims against architects. I can run through my court, right? Or wrongly signing documents or whatever it is. Lawyers always get sued for negligence, right? I think there are some professions where negligence is very much required to get a counter for insurance outside. So consider not pushing and not saying anything commission. Consider negligence, right? So as I said, mediation is really the way to go. I think the courts are so serious that each court has a mediation center. They call it court annex mediation. So in most cases that come before me, very a lot of cases. I always ask, but the problem is it's not compulsory. It is voluntary. And we always tell parties, look, we like to try mediation. Sometimes they say no, Judge, this one cannot settle. 100% cannot settle for this time. You don't have to push it. But more often than not, parties will agree. So we have court appointed mediators who are judges or qualified and trained mediators. And they may not be architects. So that's the difficulty we have one. People cannot go for mediation because they see the sign of weakness. That shouldn't be the attitude, right? Going for mediation should be the view of trying to solve it rather than a win-win situation for both parties. That should be the role. Of course, mediation now is, I think, very important because, and I think we come to architects for reports, right, or views. So when you go for mediation, you have to have some sort of basis. Look, have I got a good case? Have I got a bad case? You cannot go to mediation simply say, I don't know what the case is about. You know that it will be very difficult. So that is where the architects come in, because you have to give some sort of preliminary view to the party who's been highly likely with when you come and testify to the plaintiff of the defendant. And your views as an architect or your an expert report or whatever report is going to be there, a lot of times expert reports are critical when it comes to court. So that report is very clear, will be a guide to the party looking at it, going to lose this case or going to make this case. That actually helps mediation. The problem with the mediation in courts is that really don't have anybody who's specialized in that area. Even I do some mediation myself. I'm not that curious. It's difficult to follow. You just go there, pasang malam baring, how much you pay, how much you give. That's what I do. I don't want a decision to actually delve too much into the merits. But that is why I think under the auspices of Dr. Lim Chong Fong, who is in fact in Penang now called me, we have in the last 2 years been actively involved justice of peace mediation. I don't think it's something that we have to consider architects here. So the JPs, we have justice of peace in Penang. But the Penang government has stopped giving these JPs titles for the last 20, 30 years. So they and these justice of peace by law are actually second-class magistrates. They're actually quite powerful people, right? But with the advent of how the legal profession has moved, they really have nothing to do, right? They do not actually play much of a role. Without due respect for all of them. I think only about 30, 40 left, right? Penang. So what they undertook is exercise of doing the JP mediation bureau. So they actually train justice of peace or some other professionals to actually become mediators, right? So it's supported by the state government. They have their own buildings and I think the official building. And what we do now is, and so they give us a list of these mediators, right? They are trained managers and they are actually qualified in particular areas. So I don't know the name offhand. But there are engineers, architects, company surveyors, some even who do family law. So when we get somebody says, look, I don't mind, I want to be here, I look at the list and say, look, you might be able to invest. It's free, right? It's free information. So you can go to the center and they will actually, and they have been quite successful. I've had 2 or 3 they've successfully completed. So as a judge, there's a vesting. One case is, when I do mediation, if there are 10 files except for mediation, we put 1 successful mediation, very good. We don't do 1 out of 10. In one case, we have to sit at the bench and hear a whole trial, the lucky 1 week. Once you finish the entire week, sitting from 9 to 5, hearing the trial with witnesses, then the parties go away, file voluminous submissions. Right? You read all the submissions, hundreds of pages. Then the lawyer comes and submits, you listen to him. Once he submits that, then he will sit down, read everything, write the judgment. Then once you see a long stupid judge. So so one case takes that not happen now, but we got hundreds. So every case that gets settled by mediation is a huge blessing. I always thank counsel very much. Because record consent that I have a copy. Because it's what it is. So I think when I say the thing says see you in court again, I think it's to inform that being in court is very much reality, but it can be away. The last thing you want to do is have to go to court, get the witness box, right, and make the food, right? That's why lawyers always, the opposing lawyer is there to make you an idiot, to be architect, and sometimes they succeed in doing so. So you have to resolve to make sure what you're doing becomes that or that, right? So that's why I want to scare you. Right. After this, today I'm glad very I wish I don't know because you will hear from them, then all of them will tackle the key issues that affect the way of architects. You will first hear from architect Anthony Lee, I'm sure very well. He's a veteran in defect inspections in building forensics. As a fellow of PAM and former MD of Architect Center, he has authored hundreds of question reports and is frequently called as a court expert. Judgments make no mention. He also chairs industry working groups on workmanship standards and defect protocols. Anthony will cover the topic of defects and the consequences of badly crafted contracts. He will explain how defects arise, the common gaps in documentation, and how poor detailing, or rather no detailing, becomes a weakness in court. Most importantly, he will explain how to defend himself. Then we have Mr. Kenny Chan, the partner, managing partner of Mr. Asa Go, a highly experienced counsel. He's appeared before many times. Very impressive. His cases span negligence, land law, and of course construction disputes, including defending consultants in a high-profile retaining wall collapse inquiry and securing landmark buildings and director's duties. He will deal with the question of duty of care. I think we talk about negligence and duty of care. Not the abstract kind, but the kind that lands you in court. He will show you how the courts approach professional liability, where the line is drawn for architects, and what conduct or omissions are most often taken into litigation. Finally, we have Mr. Daniel Tan, who is a case counsel in PAM and heads his ADR secretary. He was formerly a commercial litigator and principal author of the book The Guide to Parking under Mrs. Tommy Thomas. He now oversees arbitration and expert determination of violence under PAM's institutional rules. Daniel will take you into the realm of expert determination, a lesser used but in fact a powerful dispute resolution tool under the PAM contract. He will explain how and when it applies, how it differs from arbitration, and how it can be used to break deadlocks early with less cost. I'm quite interested in that. Following those presentations, we will then have a panel discussion. In that discussion will allow questions. The only caveat I say is this: do not ask questions on any case that is pending in court. Any case that you have. People use it as a free advice session, right? Not the pending case. Right? So it's quite embarrassing where you ask for advice on a case, then the case pending is nothing to go. You told me this, that day. It's really a case before me. So it's quite embarrassing. So that's the only caveat I say. Do not ask any questions on a case that is pending in court. Right? So I'll tell you where I begin. As architects, you already carry many responsibilities. But that also means having the power to prevent any disputes. And in some cases, actually to resolve them. But we'll see about that. So, design can certify your discipline, and when disputes arise, act early and act wisely. That's today's session, to give you not just to build, but to lead. And with that, I hope you have a very productive day today. Thank you very much.
Okay, I was just whispering to Kenny just now when Arif was giving his speech, his keynote address. He was talking about all the risks you guys are facing. And he was mentioning about all the offenses, right? So I think I was just whispering to Kenny, we should change the third topic to see you in jail. No, I think nobody will come. Yeah, anyway, thanks for having us. I was just, I was booked by Option almost a year ago. He always plans my way ahead. And this week we are left with our council meeting yesterday as well. So I actually came here and had to skip chairing the council meeting yesterday, alright? 49. Alright, I'll start with this because I think this is the only recourse you have. If you all fails, and I think go to Feng Shui. So I'm just going to do a simple exercise here because this is this year 2025's Feng Shui. So the hall here, where we are sitting now, is all in front here, the southeast south. I checked the orientation this morning. So all of us here in the front here, okay, let's see who are the ones who's going to go to court. Okay, if you look at here, number 5. So number 5 is that corner there. Alright. So all of you guys, you like to go to court. And then this side all the quarrelsome one. Number 3 here. So everybody here in front, you want to move up front here? So architects beware, I came to the talk here in 2018, and I did this 10 because 10 years when Architect Center was 10 years old, I went through 10 common issues that you guys face. And I see some new faces, so I think you will in practice yet. And I see some of them here who have lost more hair. So this was the 10 years of Architect Center inspections. I came here and I did a summary of my findings. And I think I remember telling you guys of the 1,000 over inspections we did, 500 came from demand. That was our dinner topic last time. Okay, what's happening here? I think at the time, there were a lot of expats. But you guys, MM2H, Penang is the number 1 destination. So a lot of end users were expats. So they don't hesitate. If something goes wrong, they'll see you in court. Or rather not you, they see the person in court. Okay, so at that time you can see are they still here, the same sponsors? No. So we got new range of sponsors today. So what is the defect? I mean, a lot of this question was posed to me when I was involved in one case, and when Daniel was actually then working for the firm that was representing here. He asked me this question. Hey, Anthony, you are defect expert too. It's a defect. I said, oh my God, it's like I kept thinking about it, and we couldn't find the definition so easily. Right? Your version of defect, my version of defect. What is a defect? So it's not easy to define. So this is a generic stuff. I just got the generic definition. So you can work it out whether you think this is correct or not. Okay, I can't define it. This is what I generally found about the definition of defect. Not construction defect, just a defect. And what is a defect in construction? So this RACS in UK came up with a very new book, 2024. So it's quite good, and I think this book you guys should get it for your non-chapter library here. It says any imperfection of flaw or fault in construction that results from poor preparation of materials or design. Okay, so and that does not meet the contractual specifications, building codes, or industry standards. Okay? So that's the definition. Defects can be structural and so forth. Don't worry, the slides we shared with you all will be uploaded in your local website, your local your website, amongst all the others. So this part is interesting about that the issues to do with latent defects. As you know, you guys are still on the job, you still be paid for the LP period, hoping that you don't have so much defects. But then suddenly, month 48, you get a call, and then you say, oh, something's gone wrong. So latent defects also come in here. I think that Daniel will also speak about limitations or we discussed it during the panel session. This book here also, Yang Arif Dato' got a whole bunch of people to put this together. I was also asked together also with Daniel's team back then in the firm on the side. We crafted the chapter 8 on defects. So this book is very legalese. Okay, so it's not very helpful for architects. It cites all of the relevant cases as far as what was decided and how the angle was, as far as all the definition of defects are concerned. But I think the key issue that I want to bring forward to you as a reminder is that we, as contract administrators, as architects, we are in a very dispute-prone industry. We have to face it, okay? Because the PAM form, and the form that you're so familiar with, has been crafted so adversarially. There's nothing much to negotiate. It's either you die or I die. It's either you get LAD or I have to pay loss and expense. There's no in between. And you are the person who will decide whether the contractor or the developer either pays the loss and expense or gives the LAD. And today in KL, I'm telling you the project that I'm doing in Benaburi, when I tender the jobs, the LADs are $500,000 a day. There's some jobs that actually ask for $1 million a day. One day, 1 million LAD. So do you think that as architects here, when you're assessing EOT, and most of you likely don't use Microsoft Project or Primavera, you don't really generate the bar. But in Kuala Lumpur, which is actually happening here now, there's cases that you're not aware, they are using softwares to generate to the rate. Why? Because the LADs are so high. So even the LAD of $200,000 rated to be very common because the projects are so expensive to the end and you cannot even afford it. And what happens is that you, as the architect, suddenly say, oh, I need to make some changes. And then what do? You know that you may have overlooked some information and you have to then tell the contractor you're going to have to fix this and it's going to take more time. Are you going to take the responsibility of the $200,000, $500,000 of delay? Of course, you will try to talk to the contractor, hey, just try to help me here. But it's $1 million a day or $500,000 a day. And the preliminaries are crazy. And these days in Kuala Lumpur, and for many large projects, they actually have an additional consultant in the team. And also on the both sides, it's called relay people. They actually have programmers and all that. And that to me is the missing link. The architects, either you train yourself or you decide that you tell the developer to hire these people. Okay, so I'm sure you guys know about these topics I do all the while. Defects, obvious at CPC and during ELP. These are very obvious. It's very easy for you guys to pick it up, right? But not so easy once the owners move in, correct? That's when you know they will give you all the stickers, correct? All the report with the stickers. And that's where today, you know, the classic thing for luckily it's been taken out. But it's not going to stop the fact that something is going to evolve again. But latent defects now become a big issue because you have left, the whole team is gone, and then suddenly you get a report from me. Right? So no visual signs at completion, hidden becomes apparent. Then defects in housing sales and application. So this one you all know what a pain bugbear. We all spend more time at the end of the project and during the project. And then defects in construction and HDA. So all of this becomes an issue. Okay. So I'm just this is all quite basic for you guys. I've been here so many times saying the same thing. But I'm putting it all together again for this purposes to say that your job, as far as managing defects, start very, very early. Prevention, designing properly, and knowing that technical knowledge, making sure that whatever you're doing at the construction site has to be addressed before you even sign off completion, so that you try to reduce the amount of defects later on. Right. Now, you see here, defects range to perfection for determined decided by architects, engineers, and so forth, right? And this one here, only as far as who's responsible. So I'm just putting all this together. You guys can use it for your breakout discussions in your chapters later. Right? You know the sticker man, right? When they appear, yeah. So this is what happens. In fact, these photographs taken by me last week near my area where I live. This project is so new. The owner just got the keys, they haven't even started moving, and look at the amount of defects. What's that? Can somebody tell me what are those defects? It's the floor tiling, right? Yeah. And what else other than the floor tiling that's demolished? It's the screening. And the screening is like 4 inches thick, 3-4 inches thick. And they're demolishing everything. It's a brand new house. You know? And if you see the tiles, they don't even stick to that. They don't even stick to it. But this is like such a common problem in Malaysia that's scary. Come on, put me out of business, guys. I'm about to retire, okay? So, I don't want to be another sticker man for another 10 years. Really. These are very low-hanging fruits that you guys can prevent. But it seems to happen all the time, so I took a little bit detail here. Look at that. So you can see the imprint right off the top. What does that tell you? There's no application. And there it is outside. You've got all the MAPE and the SICA and all of the people there telling you, hey, do this. But why is this still happening? Okay. Look at that. Driveway. So, although CIDB has reflected this last year, as you can see, CIDB reflected the guidebook for homeowners, but the characters behind this are still there. They are still going to show up at your site in some way or another. So the problems go away while the defects are still there. So all of us supported this reflection, including us, PAM and planners. We supported this reflection from sticker man. They come and they use plastic and they stick it everywhere. So if that happens, you know that I've circulated this to you all already about the practice that's been circulated. But what happens is that although you can try to defend your position, but you are going to be defenseless if the defects are obvious, right? I mean, it's helpful when the defects are marginal. You say, look, I'm okay with that. Then somebody else says, oh, reasonable purchaser is just very fussy, But situations like photographs I showed you earlier, do you think that needs the sticker man to come and stick? Do you need classics and all? It's so obvious. So I call this new trouble. Defects have become new trouble. When I started the journey of Architect Center here, started you were with me, 2008. Okay? Yeah, that's now quite a number of years, right? And some of the first few timers that are here now, I think up to you also here. Back then, the defects were still very periphery. That means the challenges were still in POs and extension of time and LEDs. But today, I get called up to do defects inspections for plot reports almost weekly. Okay? It's become mainstream. It's no longer a side issue. It's now mainstream. So along with delays and content, I think Ken, you are arbitrator now. I'm sure you agree with me that once somebody triggers a CIPA, once somebody triggers a claim that's set off. So the moment somebody says you owe me money, the other party will say, I'm not paying you because you have defects behind. And then I'm going to take your pension money and I'm going to deduct you and then the bank charge you. The whole fight starts. Okay? So this is when it's you in court. So this is the matrix that the judge is alluding to as far as the relationships. You all know this is very low hanging fruit. The consultant architects are engaged by the property So you are bound as a professional. How are you bound? You're bound under the Architects Act, right? You're bound to perform your job independently and properly. Okay, so you're bound by that. Okay, and on top of that, you have to administer the PAM Form of Contract. On top of that, on the right hand side, you also have to administer the sales negotiation. So with that alone, you know the amount of work and the responsibility that you are faced in statute and in contract. And then when the builder comes, some of us have to contend with some projects today where we are the design build. So you are part of the construction team. KL and now even JKR, most of the projects today, the architect doesn't get employed by the developer because there's no developer. The builder becomes your boss. So I now in Benapuri, I hire architects. I have approximately now in my hand about 10 teams that I do. One project that I've done with KL into, right? Old one. So that's design build. Then went to a full scale dispute as well. Okay? And I sued my architect there as well because of issues. So in those instances, why I had to resort to taking that architect's call? Because, like I told you, as an architect, as a builder, my LED was $1 million a day. And if you don't issue me drawings on time, you issue me drawings as the builder, and I can't build what any information is wrong, you're gonna have to get it. So the matrix of the parties then also, when the builder gets sued in any of the contract, the builder might sue the subcontractors or the material people. So the whole matrix of lawsuits become very complicated. And then here, with the JMB and the MCs under the Short-Term Act, the developer now has a duty of care. It's clearly in the law residence case we discussed later on common property issues and also issues to individual units affecting common area. So now the strata owners also become part of this issue, which I think people guess here who are owners of properties. So common disputes over defects are all I highlighted in red. Okay, here. The red portions of the design certification supervision issues, non-compliance of sales and purchase agreement, tribunal issues, set-offs, and back charges. So a lot of work, more than most architects' fees. I'm not trying to ask you to come into this area because it's not an easy area to go into. Now, I saw this on Wings. This is the new norm, even in Penang, right? I think I saw it. I don't know whether this has been launched or not. I just picked up some item here saying that to look there's a mixed development for affordable housing. I don't know who's Penang. I don't need to point the project, but I just saw this article. It's quite new, right? 2025. It says here, a proposed strata mix immediately trigger your strata management act. Okay, then it says commercial or residential hospitality. So 3 types of projects. You know how difficult that is. Then you look into the development in 2 phases, which means you're not going to have an F1 and F2 already. And if you didn't pick this up, you're going to be in trouble. Then the other one will be 820 office suites and 160 rooms hotel, commercial office suites, affordable housing units. So the moment you go into the lift, there's going to be a guy wearing sarong and short pants with a guy who's a doctor because of the medical suites, and then somebody who's carrying his luggage. So this is a typical possible. And these are very typical even in here. And you are now the architect, you are given this brief, okay? Including 104 compensational housing units and individual titles and so forth. So my point of raising this is the new norm of projects today. You don't get a single terrace house, a single short houses and all that. This is Penang today. And this is really, and then in KL we have added one. They got one train and then running underneath. Or an LRT running on top. So the TODs, transport orientation. So lifespan of disputes, you look at it here, how long all of this will take to manifest, and believe me, these are all banana stories, okay? With all the different people attacking each other. Right. So moving on from traditional to new norm, you guys know about my current contract talks. I just want to remind you, these are some of the new norms today. Okay? No longer PAM form, But you're going to get design build, you got international PMCs coming, China contractors, they go missing after a while. Okay? And then the PAM form gets molested. I don't know how many of you guys are still picking up with the PAM form that gets molested. Right? Why are you allowing that to happen? And then you say, oh, the QS is the one who did it. Come on. You guys are the guys who are running the contract. If the PAM form gets molested, you are going to be very difficult. And you know where the common molestations are, right? Read the contract, maybe we do another talk. And this was one of the contracts that I did. This is a current contract. I was a customer in this year. I was the main con. I did a project in Thailand. I've shared this like many years ago. And that's it. We wrote the whole contract, DQ agreement, everything. And the last sentence says, if there are any discrepancies or conflicts in this contract or statements set forth in the documents of information, the statement given the best interest of the employer shall prevail and apply. Nice, huh? And then my guys dropped their hands and accepted it. So we had to go to a Bangkok court to fight over this. So it's not only in my flaws, interesting. So what happens is for you, architect, very easy. You should put these flaws. And then this one I've shared with you. I think some of you have probably visited this building before. It's a very tall building with funny shape near the stadium. So this was the tender condition that I went in as a main contractor. They say it's a build only. And you just read this. This was done by a very large international PMC company, starting with T, okay, or T. So all it says is, this is the condition. No drawing suspects the scope of work, may not necessarily describe in detail all the works required performance of the works. That's the first sentence. Okay? However, the contractor shall execute all the works required so fit for the intended purposes. What purpose? Regardless of not whether they are specifically shown or described in the scope of work. Regardless, okay? And then it says here, the contractor shall provide all items for the proper execution and completion of the works so far, what specs? No specs. In fact, this was for the roof of the building. No roof. When I looked at the tender, there's no roof. So I said, there's no roof. It was clouded in the tender drawings. So then they say, you have to read this clause. I sent this to Dr. Chong Fong, just as a, WhatsApp business code or some product. But as an architect, if you decide that your team writes this in the contract clauses, what happens invariably? You're going to get a dispute. And as I predicted, parties have gone into dispute. I tendered for the job, I saw this condition, I asked the project managers, I said, hey, what's going on? He said, oh, you read it. I said, oh, thank you very much. I left it. It was a $700 million tender. But this is the kind of conditions that okay? Oh, I think it was an invitation for dispute contract. It's called. And then now with your new PCWD, right? I think David came and gave you all a talk, scare the hell out of you all as well. Okay, so I asked him, I showed him this picture. Would the architect not be liable for this under PCWD for permanent design? You look at the icon edge. If somebody falls down and the building is for life, you design that icon edge like that. I don't know. I'm not the authority here, but somebody is going to use PCWD and whack you guys. Okay. Right? And last night, the leader, I can tell you all, Penang, you guys got a time bomb here with your glass handrails. So this is what happens, huh? I don't know. I can't tell you about this PCWD where it's going to get. But it feels like it's going to get to the point where the architect and the engineers will be responsible for the building where you cannot attain safety. I mean, you were part of that design that caused somebody or something to fail, somebody had an accident and so forth. So this one also, same thing. How do I get on the edge? Okay? And then the other bits is when the architect puts bathrooms and toilets above and electrical rooms. I see this every time, day in, day out, I see this. So below here is it's a switch room, okay, and you got many penetrations on top, and with all the tabs. So, question: is this a design issue, a workmanship issue, or a maintenance issue? Can I just have a few audience? Come on. Is it 1, 2, or 3? Number 1, right? Yeah. Has it anything to do with workmanship? So this one is actually the top here. I'll just show you. This is the top. The top is just that right corner there. The top of it is just a granite upstairs. And then at the bottom you can see the cracks in the leaking coming down. And directly below it is this switch room. So what they did was they actually very cleverly installed this tarpaulin sheets. Yeah, so that's all the problem. Just waiting for another bomb to explode. And this is for the life of the building. It's not like a DLP issue. So I'm just going to jump quickly into this one case that I was involved in. The report that Architect Center did was in 2010, and it finally got caught in 2019. And that case was originally presided by, I think it was Justice which said that after it got elevated, with the form case. This case is a very straightforward matter. It's between the developer, who was then EMO, one of the subsidiaries of EMO, and the owners who were residents, just like all the residents. So it's in KLCC, it's a very high project. We had to go in and do an expert report about the condition of the leaks and all the other issues that I'm sure you all know. Now, finally, the judgment just says, look, it was novel in the sense that because it was the purchasers suing the developer for common area problems as the MC. So it's not like a personal owner suing somebody, suing something for that condo that they purchased, but it's a strata. So in the sense, it's quite important that in Penang now, you have so many strata properties. I showed you the earlier projects and all that. The complications comes with mixed development, strata, mixed ownership. It's even going to be more complicated than dual residency. The issues that you're going to face with defects are even going to multiply a lot more than dual residency. But in this case here, the key is that it's a duty of care to the MC. Now this case has been cited a lot in most of the issues to do with defects here, and also in dealt with latency. So these are some of the pictures that I took by drone on this particular project, and there was the legal disputes regarding that swimming pool, the leaks at the swimming pool, and also the leaks at that open deck. Okay, so the right hand side there is the Jalan Plaza. So some of these are some of the documents that I used in court to explain all of the areas of the disputes. But in this case here, there was a dispute regarding the leaks to the construction joint and also through the swimming pool as well. Okay, so these are some of the PowerPoint slides that I actually used for this matter. Okay, so I'm just explaining to you that this is some of the issues to do with the PU injections that didn't work. Now this one here, I've shown you before, it's my own project in Sabah, where I'm the main contractor. This is actually the state government building, yeah, the Architect Center, and I built this building. And I didn't do the design, I only did the construction. And one of the specifications that the consultants presented to me was to say, you build this concrete with this design and you add these things into the concrete and then you apply this on the project. So I followed everything and then it leaked. So I brought the issue up to say, look, I only follow what you did, and if it fails, it's your design that failed. So obviously they say, no, your workmanship didn't do it properly. So it becomes you say, I say. So this is a very typical kind of dispute. Okay? And then they start doing PU grouting and all that. So in Penang, I'm sure you got PU grouting. It does not work. I've showed this slide before. In fact, this went to court for the dual residents between 2012 and 2018. You can see the leaking moves over the years. Okay, I inject it, the leak moves. I inject it, the leak moves. So it does not solve the problem. It just keeps pushing the problem. So the leak progresses. So these are again the leaks occurring over the electrical rooms. So finally, you can see Daniel there. He's still young. I think he hasn't aged just then, but definitely I've aged. So this was a photograph taken after the court action. In this case here, they filed for damages, and with the money, the MC carried out the repairs themselves. So this was actually part of the repair that occurred. So you can see that they ripped everything out. Okay? This was some of the children's pool, and this is the main pool that they had to rip. So you can see the cracks on the concrete that had to be repaired first. So this kind of repairs are the only way that you can fix leaks from swimming pools and water tanks. You can't come back and inject from the bottom. It has to be done like this. You have to start all over again. In this case here, something's very interesting. The engineer did not design the concrete structure to retain water. It was all discussed in court. Even the concrete strength was inadequate for that purpose. So therefore, it relied heavily on the waterproofing. Do you think that's going to work? So as I speak today, I invite Penang chapters to join me in my working group to redraft the waterproofing standards again. Because I'm looking for volunteers. I've got a few. But I need more people to come in to draft the standards because as we speak in Malaysia, we don't have a mandated waterproofing standard. Okay? I'm going to share with you more when you join the working group. So you can see all the cracks here. So how can a waterproofing bridge those kind of cracks? Impossible, right? No membrane can do that. Okay, so look at that. These are all the main things that you need to look out for. Okay? Design, workmanship, and maintenance. To look for determine the root causes. Okay, I think that's quite obvious, right? Avoid designing building defects and disputes. Because when I say avoid designing building design and disputes, is because number one, you had inadvertently designed a dispute into your contract by first of all allowing the contract to be molested. First and foremost, you saw some of the samples I had. But when the contracts are so one-sided and you try to build in everything into the contract, no way you will be able to escape. Somebody is going to sue. Whether they win or not is another thing. It is so damn inconvenient. So run a proper PAM Form of Contract. Even though you are asked to run maybe a non-PAM Form of Contract, be familiar that don't put in all these funny clauses into it, number one. Number two is obviously the professionals that you are, the design is very important. The materials are very important. Zawa, you are here, you know the issues with fire today, right? We took so much trouble just to draft up a book over 4 or 5 years. Zawa was one of the authors to draft this thing so that Bomba doesn't come and look after you, look for you, and you are going to be able to have a manual. So it's a work in progress. So I see many of the chapter members here. I see some old friends here. I think it's time for us to step back. Let's take some of the younger ones. You've got a very dynamic team here. Please, get involved with federal issues. Okay? So I think that takes me to the end of my session. I'm going to see you all later during our panel discussions and the Q&A. Okay, thank you very much.
Good morning. Thank you for inviting me. It's indeed a real pleasure to be here this morning with you. My topic for today is can purchasers sue architects, and also an understanding of the architect's duty of care in Malaysia. Now, this is a topic that you always hope it will never happen to you. It could not happen to you. It should not happen to you. But there is always that possibility that it may happen to you. Last week, I heard a speaker make this very profound statement. He said, never believe your doubt or doubt your beliefs. Always believe your beliefs and doubt your doubts. But if you are sued, invariably you will begin to doubt your belief that you have acted accordingly, competently, correctly, and you will begin to live in your doubts. In my career, I had the privilege of representing 3 very distinguished members of the profession. And I had the experience of seeing them close up, the mental and the emotional stress that begin to a person being sued. When you are sued, and in the face of many accusations, allegations, even if you thought that you know that all you have done was in compliance with the standards of your profession, fear and anxiety will still invariably creep in and affect you and consume your life in some instances. So what I want to show you in this short time this morning is some of the instances of how purchasers have advanced claims against architects. And also, more importantly, how local authorities will look to impose a duty of care on architects. And I hope in this short time to provide some guidelines of what to expect and how you can better prepare in the face of such claims or such allegations are made against your profession. Now, very quickly, let's look at privity of contract. Everybody knows basically that privity of contract says that it's the natural understanding that only parties to a contract can sue for breach of it. And in normal circumstances, purchasers have no direct contractual relationship with architects. So essentially, architects therefore owes no contractual duty to purchasers. However, when it comes to the law of tort, negligence, the courts will always look at the central point is that was there a sufficient relationship of proximity between the architects and the developer, and the purchaser. And the duty of care can arise, and breach of it can therefore allow purchasers to advance a claim for negligence against architects. And one of the areas that they will always look at is whether there was an assumption of responsibility from the architect. And what I want to do now is I want to show you live case bernard, as what Anthony says. 3 very case bernards of how these kinds of principles of law have featured in the cases that I'm going to be dealing with. The first case, of course, is the case that involved Dr. Loh Chiam Yong. This was a case by Loh Kok Beng against Dr. Loh Chiam Yong and Mr. Loh Kee Peng. I had the privilege of being appointed as lead counsel for Dr. Loh. And the brief facts of this case are such. The plaintiff claimants, now they were purchasers of 50 units of industrial buildings. And the project architects were appointed by the developer. And that there were no signed agreements between the purchasers or the architects. The only agreements that were signed was between the SPA, between the developer and the purchasers. So from the outset, we know that there was no privity of contract between the parties, between the architect and the purchasers. Now, this was a very interesting project because it was a special industrial project. One of the mandatory requirements was that the developer was required to build a toxic waste treatment plant, and that was in accordance with the specifications approved by the DOE. Now, this treatment plant was known as the Central Effluent Industrial Treatment System, short form CEITS. And this was run by the DOE. It was to be designed by a specialist that was approved by the DOE, and it must be functional and it must be operational to the satisfaction of the DOE before the architects can issue the CFO. Now, what were the purchasers complaint against? Well, it was interesting because VP, vacant possession, under the contract has to be delivered within 24 months from the approval of the building plan. However, in this instance, there was a delay of 8 years. And more importantly, the developer went back young. They basically got locked up. So there were no guns to be trained on the developer because there was no remedy against the developer. So the purchasers decided to be very creative. This was very novel. They decided to take an action against the architects to sue for taking the building. And their case was actually fashioned in 2 points. They say that architects were negligent for two reasons. First, the original layout plan that was submitted to MPS, they had to be amended. It had to be amended because there was originally, the understanding was that there would be a slope cutting, and therefore that was the plan that was submitted. But when one of the landowners, adjoining landowners, refused to consent, it necessitated an amendment to the plan. So there was therefore the negligence that they fashioned up was that the architects were negligent because they submitted the original plan on a wrongful assumption that neighboring owners had consented to the slope. The second point that they did was this. They said there was a delay in obtaining the CFO because the architects refused to comply with the developer's instructions. And the instructions was to apply for a CFO, even though DOE had not approved the CIDS that it was instructed and it was functioning to the satisfaction. So those were the two reasons why they fashioned the plan. At the high court, we actually lost. 50% of the damages that they sought were awarded against our clients. And I must take the opportunity to thank and Mr. Lokibe because they kept faith in the team. And they allowed us to pursue the matter to the Court of Appeal. And after the Court of Appeal, when the judgment was reversed, 3-0 judgment was reversed in our favor, the purchasers took us to the federal court. And they obtained leave. And after the hearing had gone on, it took 1 year before the federal court delivered the judgment. So all in all, the turmoil or the mental and emotional stress of carrying this for Dr. Loh and Mr. Lokibe was 16 long years. That's how long. And you could actually see the burden each time we meet with them. Now, what was the decision of the appellate courts? The appellate courts found this. They said, as architects, you are mainly responsible for the design, for the safety of the buildings, and compliance with the relevant laws. So layout plans were prepared in this instance and submitted in accordance with the instructions of the developer. And the court noted, crucially, that since the issue of consent of the neighboring lot was within the scope of the developer's duty, it would not be reasonable to impose a duty on the architects to go into a detailed inquiry of this issue. And the court perused through, because the bench was led by the Chief Justice, and the court perused through the entire set of documents and noted that there was nothing in any of the documents to suggest that Dr. Loh or Mr. Lokibe had assumed responsibility to ensure that such consent would be obtained. The court also noted in the documents that the CEIDS construction was not within their job scope. It required a specialist licensed by the DOE and was to be constructed crucially by the developer, not the architect. And so the court concluded that it would not be fair, just, and reasonable to impose on architects a duty for a responsibility which they had neither assumed nor was it within their professional scope of duty. Now, what are the takeaways that we can learn from this from your daily practice? Well, first and foremost, this case established that a case for negligence can always be made against law architects, even in the absence of a contract between you and the purchasers. Why? Well, because when you discharge your professional duty as an architect in a construction project, the purchasers and even the developer, they rely on your skill, on your expertise to ensure that the construction is done in compliance with the laws. And so the key that this case taught us, and moving forward in every case that we handle, we always look for this. We identify first and foremost whether you can be made liable or not. We look at whether your scope of duty, what you have agreed upon when you undertook your action. Therefore, from a practical standpoint, it is very important when you discharge your duty, you ensure that your duties within the confines of your letter. If you go beyond that, then the court will look to say that you have assumed the responsibility and extend that liability and the obligation to you. Secondly, this case taught us that you need to be independent. I think Mr. Anthony mentioned that. You need to be independent. You cannot simply be subservient to the developer's wants. Why? If you are asked to compromise on the standards of your profession by a developer, to basically cut corners, to cut costs, and it may endanger life, this case establishes that it is your duty to walk away from that project. Otherwise, you have assumed the responsibility and liability will be extended and judged accordingly. So that's the case that was very interesting. It's that was a global case, and it is still being referred to last I checked in many of the cases that deals with duty of care, and you may want to look at it more detailed. The next case that I'm keen to take you through is a case that involves one-time job development. It's close to the and one-time job development is across the country. And this case, the brief facts were as such. The Management Corporation, the MC, they engaged Architect Center Sdn Bhd to identify, assess the defects in the common property of the development. Now, at the High Court allowed and directed the developer, allowed the purchasers of the MC to establish a claim, and directed the developer to undertake repair of the defects that were identified. But the High Court rejected the claims for non-compliance with fire safety regulations. This case then, in part, appealed, we went to the Court of Appeal. The Court of Appeal wrote a lengthy judgment, and they rejected the appeal. Now, what are the takeaways for this case? Well, first and foremost, we need to note the distinction between what happened in one country and what happens to today's context. Now, in one country, the CF was actually authorized or signed off by the local authority. It wasn't a case of CCC architects. And the court determined, therefore, that any responsible or any sustainable claim that you want to have, the MC should have advanced their case against the local authorities. Why? Because they said, the court determined that your case should have been against the local authority for, number one, having wrongfully approved the building plan. Number two, wrongfully issuing CF even though the developer had constructed the development without complying with the approved building plan. So this case seems to suggest that when it comes to non-compliance, this case identifies that it's not the developer, but the party that certifies the CF as the responsible party for anything in court. If it is against the defects, it will have the developer. But if it is against the court, the negligence, they go after the party that certifies it. So in today's context, how does it apply to us? Well, in today's context, your CCC is issued by the architects. And what it means is that when you issue your CCC, you are certified that the building is constructed in accordance with approved building plans and compliance with relevant laws and bylaws. So the purchasers essentially can pursue an action against the architect if they are able to demonstrate in court before judges such as Justice that they can show that the CCC was issued without such compliance. And authorities and purchasers can pursue against the architect if the fire safety plans had breached the UDR 1984. So in the case of one country, had it being a CCC that was issued by the architect, and it being that the case was advanced against the architect for wrongful issuance of the CCC, then, in my opinion, the judgment doesn't talk about that, applying the principles, there would have been a very high chance that the Court of Appeal would have decided favorably for the MC and found liability in judgment against the architects. My final one, I thought not scary you all. I want to use the word that I think Justice Adnan used, satu kampung. This is a case that was very tragic. This is a case involving the collapse of the project in Argentina. We identified as the project. And this was a case where satu kampung was brought in because you had the architects, the engineers, contractors, and every other person. There were plenty of lawyers in the SCI. And I had the privilege of being appointed by Dr. Tan as his personal counsel to represent him, the architect, in these proceedings. Now, the brief facts of this case were such. On 21st October 2017, a group of foreign workers, they were preparing for casting of concrete. And this was part of permanent works. Now, these works were being undertaken at an area that around Paltec was numbered as Paltec E17. Around 9 a.m., tragedy occurred. Because at the man-made slope near Paltec, then the consequence of that tragedy was that 11 souls were lost. One of it was the supervisor that had just started work the day before. And so the commission of inquiry was gazetted and established. I'm going to take you through what was the consulting engineer's position to push the problem of the blame to the architect. And I'm also going to take you through, crucially, how the local authority viewed that the responsibility lay with the architect. But there's a happy ending to the story. So, now, the consulting engineer's position is this. He says, the architect is the superintending officer of the building works at the time of the tragedy. So if the situation at the site was deemed to be unsafe for work, as the ESCO of the building works, the authority to issue a stop work order doesn't lie with the engineer, it lies with the architect. And so he argued, contended before the SCI that the failure to do so meant that the architect was responsible for the tragic consequences that ensued. Then we had the council that joined the party, and we thought the council would favor us and impose the liability on the engineer. But this was what the council did. They said the undertaking given by the consulting architect as principal submitting person is endorsed on the building plan. And when you endorse that on the building plan, it is akin to a pledge, a promise, and a guarantee to MVP. And the undertaking, I think you'll be familiar, containing the following. I'm going to read it to you. It says, saya mengesahkan bahawa kerja-kerja pembinaan akan dijalankan di bawah penghiliaan saya, which means that I guarantee or I certify that all these works are done under my supervision. And so the council then said, any breach of the undertakings given by the architect to MEP, it would amount to grave impropriety and a serious dereliction of duty, and will have serious consequences under the PPL as well as the Street Drainage and Building Act. Now, what was the reason of their conclusion of their contention? Well, they say this: the person that MEP had granted the commencement of works order (COW) in respect of the building works, it was to the submitting person. And therefore, they conclude that although your duty as an architect is primarily to your client due to the contractual relationship, in law, the architect will be liable to MEP and to anyone sufficiently proximate who whom he should foresee that his act, or in this case, failure to take steps to ensure the safety failure to issue the stopping order will cause damage to the person and the team. And so they went on to say that since the architect was engaged by the developer to design and supervise the construction of the building, it was incumbent upon him concerned with the surrounding area when the building is erected. And so their argument was that the architect, it's the duty of the architect to ensure no soil from the temporary structure that was designed by the engineer would come crashing down on his building design. And MPPT contended that though the architect may not be responsible to supervise the earthworks, but as the PSP, since he was the only person who can sign the CCC, he is to be accountable for the building works, earthworks, and therefore the safety of the constructions. That was the council's position. They pushed the problem to the PSP. Now, the commission made these findings. Was led by Dr. Liu Yang Kuo. The commission said, first, for any acceptance of the role as an ESCO of any project, there must be clear demarcation of your duties. Okay? And I cannot emphasize that enough. You must mark out what your duties are. And there must be clear exclusion of responsibility on all engineering matters. Because invariably when you do construction, you will have an engineer and an architect. And what the commission noted was that it is presently missing in the common practice of the building industry. And that was what they noted, and they advised that it should be rectified. Because the commission said, while it is acceptable and understandable why architects want to be as code, reason for being in control of administration of contracts and or financial matters, architects must be careful to confine your powers and your duties to matters of administration of contracts. And what the commission said was that presently, your industry or your profession, you are quite content, that's what they say, to give the proper scope of an ESCO's duty to be subjected to an inference in the interpretation of the contracts. So those were the things that said. And they went on to say that if the architects continue to ignore the present deficiency in your contracts on clearly spelling out your job scope, your duties, architects will be subjecting themselves to the very real possibility of a different interpretation by the courts of their contracts. And you will then show them this. I want to now just leave you with a number of takeaways. How we then, in the face of this, my team, together with Zalwa, who assisted us greatly, and she's very embarrassed, but her assistance was invaluable. And how we designed the defense for Dr. Tan and to ensure that there was no liability attached to him. And the starting point that we took was that we wanted to determine the scope of responsibilities governing the works related to this project. We extended, we took what we learned from the case of Dr. Road and we applied it here. And we established from the outset that on contract there was no assumption of responsibility that went beyond the scope of expertise of the consultant. That was the first thing that we built our case on. And now, why is it so important that we establish this? Well, there are 6 reasons. First, under Article 4 of your PAM contract, and it says that the engineer shall perform the duties expected of his profession. The architect may from time to time delegate, most time to time delegate such duties and authority of the architect to the engineer as the architect in his field. Then conditions of contract, conditions 1.2 under the heading of temporary works and construction method provides, unless designed by the architect or consultant, the consultant shall be fully responsible for the adequacy, stability, safety of all temporary works and of all methods of construction of the works, irrespective of any approval by the architect. Then we went on to the G forms, and we looked at particularly the Form G1, which is for earthworks, and Form G4, which was for structural works. And under these G forms, they contain the following words: kami memperakui bahwa kami telah mengawasi dan atau menjalankan pembinaan dan penyiapan kerja-kerja tanah. So this clearly shows that it was under the engineer. Thirdly, we rely on the Board of Engineers Malaysia Circular for Supervision of Construction Works, and it reads, Act 133 SDB only allows qualified persons to supervise and certify completion of construction of engineering aspects of buildings. No erection or continuation of erection of that building works shall take place unless a qualified person or any person duly authorized by him undertakes the supervision of works. This means that the submitting person shall supervise construction works, and the submitting person shall not certify construction works unless he or any person duly authorized by him has carried out the supervision. Fourthly, you might want to look at this following appendixes that was prepared by the Joint Committee from both boards, architects, and engineers. This slide shall be given to you when my time is up. It seems like in federal court, but we also bring the bell with us. And you might want to look at this later on, because this will give you defense on that. And the other two is that the guideline of role and responsibility of engineers like temporary works during construction. And the last one, the code of conduct set up by the Board of Engineers under the Registration of Engineers Regulation. Now, in conclusion, because when it comes to earthworks, temporary works, the safety and stability of the slope, as it was designed by the consulting engineer, so both contract and statute imposes on him a duty to advise, to supervise, and be responsible on all works pertaining to this. So the architect was not held liable for
Morning, fellow architects. Daniel Tan, the case counsel and head of the PAM Secretariat. Now, I'm the fourth speaker for this morning session, so rest assured, my session will be light. Actually, I told Kenny that initially I wanted to be before, just behind the rostrum, but I needed the teleprompter, so to be on stage. Now, my session is mainly an extension of what the speakers have covered previously. Okay? Mainly that architects wear so many hats, and now construction projects are getting more and more complicated. And your dealings with so many parties only mean that there are a lot of decisions to be made for each project, right? And you're not running one project at one time. It's so many projects running concurrently as well. So that adds on to the layers. So that's why I'll be talking more about how we can leverage your position as an architect to perhaps prompt early resolution of disputes between the parties and perhaps promote expert determination as well as a potential mechanism for parties to rely on. Now, before I begin, I have one question, and this is not a trick question. I used to be a lawyer, but not anymore. So what do you see here? Not a trick question, you're not the cross. So just ABC, right? Not a trick question, just ABC. But now, if you can focus just on the middle part, what do you see now? It's now 12, 13, 14, right? But what has changed? If you look at the middle portion, you compare that with the previous slide, it's completely the same. It's identical, right? It's the same image, but what has changed is your mindset, your perception. For the first one, it's between A and C, your brain automatically tells you, must be bigger. Second one, because it's between 12 and 14, suddenly it becomes 13. Right? So this tells you really that your mindset and your assumptions shape what you see. Now, why this is important? Because this also influences how you see disputes. Now, the traditional one is because we are all used to, oh, you have to do the call, who's right, who's wrong. So that is the default setting of your mind. Who's right, who's wrong, let the judge decide. Okay, right? You have to pay what to do, right? But the alternative approach is, okay, fair enough. Just like in any relationship, doesn't matter who's right or who's wrong, but how can we solve a problem? Right? Instead of ego-driven, just focus on the benefit that everyone can achieve if you just focus on the problem. Okay, so that is the reason why I touched on this, to change the mindset. And there is some incentive for you to adopt this change as well. Some statistics for you. Now, in 2020, the average dispute value globally is about 54 million US dollars. And this is by Architect, a consultancy firm. And HKA Crux Insight has reported that in 2024 alone, every dispute is about 16 months in project release. Now, this is even more significant because the construction industry is a significant part of the Malaysian economy, about 14.2% of GDP, and that's from the Department of Statistics Malaysia. So what this tells you, if you take it in totality, is that disputes, if not managed well, if everything goes to court, will definitely affect productivity and project review. And as what we said earlier, then you can see all those LED claims coming. Okay. So I mentioned going to court and trying to resolve it early. But what is it based on? So here are just the technical aspects of those layman terms. Going to court is based on the adversarial model. Right? We took it from the English model, right? Where you file a suit, the claimant will take position A, then the defendant who you sue will take position B. You have to prove your case, you submit your evidence, but because it's skewed, the evidence will support each party's respective positions. So more often than not, it will be diametrically opposed. And if you have got technical disputes, same thing. Expert A will support claimant A, expert B will support claimant B. And most of the times, although they are both experts, you will find that they cannot agree on much at all. And especially for the judge, if you don't have some technical background, who do you choose? Who do you trust? Because you're not the expert, you rely on them, but then they've got so different opinions on the same dispute. Right? And at the end of the day, the judge has to make a decision. Who's right, who's wrong, and the potential outcomes are fairly limited. You either win all, win some, or you don't win at all. Right? There's no room for creativity, there's no room for any dynamic approach. Right? That's why I added, it's like Kung Fu fighting and see the best man wins. Right? Now you compare that with what we call the conciliatory model, basically negotiation and mediation. Now you ask me, what's the difference between the two? It's almost identical, except that for mediation, you appoint a third party, help to bring parties together, because there are times when the relationship has already broken down. So a third party helps a lot to help identify common ground. Much like marriage counseling, you just need a third party sometimes. If the relationship has broken down to that degree, okay? And that's why, hopefully, but this is the best case scenario, like you shake hands, everyone goes back happy. But sometimes, if you cannot, at least you can narrow down on the issues. Maybe you and your wife, you have 10 things to argue after mediation, only 2. So still a good progress. Okay? And if you have got technical issues, you need some experts as well. Preferably one jointly appointed expert, so that we don't have more disputes that we need to deal with. And it focuses again on consensus, because you cannot settle unless all parties agree on the terms of something. Okay? So everyone has to be happy with it. Now, Japan is a very good example of a country wholly adopting the conciliatory model, but partly it's because of their culture. They are non-confrontational in nature. So for them, litigation is really the last resort, and they mean it. So they'll try to negotiate first, and if that doesn't work, mediate. Litigation for them, they'll try to avoid it at all costs, and the statistics support this as well. In Japan, you've got about 29 lawyers for every 100,000 citizens. Now you compare that with Australia, where you've got about 400 lawyers for every 100,000 people. Right, so the Western culture is quite different. In Malaysia, we are in between, not too bad, about 69 lawyers for every 100,000 people. So not like a Western country, but we're not like Japan. But it does mean that we have got some tendencies towards ADR already. Because I'm sure sometimes you meet people, you've got some disputes, but they tell you, it's okay, I just want to live my life. It's okay, I just move on. They don't even want to sue, although they complain to you about it. Then you say, it's so long. You say, it's okay, it's okay. So we already have got that tendency. So as architects, sometimes we can take advantage of that, because you know the pain points of artists to try to move things towards that direction. It's all about psychology sometimes, especially when the disputes are still at the early stage, right? The parties are not advised by lawyers yet. So the difference, and all this you know already, for time, if you go to court, it may take years. The courts are under strict KPIs to dispose of cases within 9 months, but sometimes because of backlog, that doesn't happen. It's very difficult to achieve also if you're talking about very complex cases involving so many experts, and this is true for construction disputes. Now, for mediation and negotiation, it really depends. If you can settle within a week, then that's the only week that you'll take for parties to sit down and to spend time on this matter. But the cost for litigation, you have to pay your legal fees, and depending on how many experts you have, it's for every expert, it's not a joint thing. Right? And sometimes, perhaps a tranche of trial dates have been scheduled, but the last minute gets vacated. Well, sometimes you still have to pay the fees because they take time to prepare for the case. And it's a recurring problem with me previously when I was in practice. Now, in negotiation, mediation is proportional because with negotiation, you're just directly engaging with the other party. So it's just your employees. So it's already cost you will incur anyway, it's not additional cost. For mediator, well, it depends. If you as an architect, perhaps you want to fill in that role, your parties are more comfortable with you because you know the facts, you know the parties. Or if you feel, I think they might feel that I'm a bit biased, and I want to get an independent mediator as well. And Justice Anand, as mentioned earlier, you've got 3 months or so who have got the experience to mediate the matter with the parties. Right? Or you feel if you want to get someone more technical, we have got technical mediators as well, but of course, it's not really the fees. Now, for relationship, I'm sure everyone here knows, you go to court, the relationship will be not on talking terms anymore, right? Because you'll be taking diametrically opposed positions, and I've heard this so many times, the document will be filed in court. You say, hey, how can they say this? It goes by this. Right? But that is what happens in court because you have to reduce your position in writing, you have to file it, and it is in the public domain. Anyone can download it and read it. There's no turning back. Whereas if you negotiate and mediate, it won't be 100%, but you can preserve a significant portion of the relationship. It will go back to how it was before, maybe before the dispute was resolved. For control as well, once you file a suit, let's say the suit will take a life of its own. That's why if you have some experience in court suits, the lawyers will always chase you for something. It's not because the lawyers want you, but because they are under strict guidance by the court rules to file certain documents by a certain time. They are under judges' directions to do so as well. It's not that they want to, but that's just how it is. Right? And there's no stopping it until you settle. Whether you like it or not. If you negotiate or mediate, well, the timeline is yours to choose. Right? Whether you want it to be perhaps more expedient or parties to take their time in collection of documents. It's flexible. And for the outcome, as I stated earlier, for court matters, arms are limited because the judges are bound by what you have pleaded in the sum of it. So it's all sum of it. Whereas if you negotiate, you can be very creative about how you want to move forward. Because it's about what you can give to perhaps party A and party B perhaps wants this. And sometimes it can be unrelated to the dispute at hand as well, especially if those parties have got other projects. Maybe they say, okay, this one I give in, but that one I want this. And that's possible because it's settlement. It can be very dynamic. As long as parties agree, then you can do it. Now, I feel that this photo summarizes the distinctive feature of the models. So if you go to court, it's like putting fuel on the fire, it will get bigger. But if you're trying to mediate, try to negotiate, and if it's successful, you're putting out the fire. Okay. And as what Justice Anand mentioned earlier, the conciliatory model has been endorsed by the Malaysian judiciary, and Justice Anand has explained it very well earlier because the background that push towards mediation. There is a court-annexed mediation as well, available to parties. And judges play a role in encouraging parties towards mediation as well, because it is what it is, but when judges say things, your clients listen. Now, if lawyers were to say you don't listen, it's like you telling your parents, yeah, I think you're sick, you better see the doctor. They don't listen to you. But if the doctor says, I think you're sick, oh yeah, I think I'm sick. Right? Same facts, but when told by a different person, it's a different fact. And that's how it is. And that's where expert determination comes in. I say, oh, hold on, you have just been talking about mediation, negotiation, and so on. Where does this come in? Now, this comes in when, despite your efforts, parties perhaps just cannot achieve anything for mediation, for negotiation and also mediation, or perhaps parties find that you are not, or they have the perception that you are not independent, that they don't trust you. And sometimes it happens, because they have got their own way of thinking. So you can propose this as a mechanism, because what it really does is, as long as party A and party B both agree, right, to go for expert determination, they will then appoint an independent technical expert, okay, to deal with certain questions. And those questions will be determined by parties. Do they want that technical expert to determine? Right? And as the name implies, normally this mechanism is suited for technical disputes. So not factual at all, but technical. So for defects, evaluations of work done, specifications, compliance, duties, and so on and so forth. Okay? And once parties agree, and the fees are agreed, and deposits are paid, the technical expert will have to arrive at the finding within 2 months. So it's quite speedy. Right? And it's all provided for in the rules, which you can download at the PAM'S website under the EDR section. Okay? And any findings made by the expert is binding, but it can be reopened during arbitration proceedings. So at least for the time being, parties are bound, and if anything, you take it later on. And the procedure for this is quite straightforward as well, because it's party driven, so it will be initiated by party A. He will submit a request setting out the name of the expert and the questions to be determined. The other party must respond within 7 days. They can either agree or disagree. If party B disagrees, that's it. That's the end of the matter. But if party B agrees, yes, I'm okay with this expert, I'm okay with Anthony, I'm okay with the questions, or maybe they have got additional questions, then party A will have to respond. Assuming both parties agree to submit the matter to expert determination, they then have got another 7 days to determine the terms of engagement with the expert. Now, if they cannot agree, PAM will step in to appoint an expert determiner. So we have got, and we are building up our panel of experts, because this set of rules was just passed, so it's very new. Right? But even without the panel, the president has got powers to appoint experts as well. So that is not an impediment. Okay? But assuming parties agree, the expert will then have to sign a written agreement with the parties within 5 days, and assuming all the deposits are paid to PAM, the expert will then proceed to determine the matter within 2 months based on the parameters set in the correspondence. Now, the expert can then gather evidence that includes written statements by both parties, and it is flexible enough to require or to seek help from the architects as well, because I assume for these things the project is still ongoing, so parties may not have some information which only you can provide as an independent party. Right? And I think if you can give it, parties would appreciate that as well. If not, sometimes there's a loophole in case analysis and you cannot arrive at what the finding is. So I'll give you a real world scenario so that you can piece everything together. Okay, a dispute has arisen between the contractor and employer. Contractor claiming, I want EOT, I'm entitled to it, and I want payment for additional works. Employer, of course, no, disagree because the delays were caused by you, not my problem. And additional works, I'm not paying because I did not authorize it. You just did it on your own. Sorry. Okay. So what do you do in this position? Do you say, I'll just proceed to assess based on my own expertise and all of that, then be done with it? Or do you say, oh, this is a bit technical, might be out of my expertise, okay? Maybe I'll recommend expert determination. But if you do recommend expert determination, you then have to decide, oh, do I want to assist the expert determination? Because you can't say no, because you are the contract administrator, you have to decide. Okay? This is not taking any powers away from you. Or, even if parties have agreed, do you want to be bound by the outcome? Or do you say, no, I don't want to be bound by the outcome, I just want to take it into account after it's out, when I make my assessment. So that's possible as well. Right? So later on, if parties were to find fault, you say, well, my reasonings are such because I rely on the findings of a technical expert. Right? So you've got some background as well. Okay? And this is just a general plan, right? Of course, it's strictly on a case-by-case basis as well. First is to encourage negotiation and mediation, especially when you see a good window for it, okay, because of the parties. And if parties remain stuck, you might want to propose expert determination if it is a technical dispute. If not, then it's not suitable and it might be disproportionate as well because you have to hire technical experts. And if parties adopt the expert determination process, now you then have to determine for yourself as the contract administrator how the findings will bind you. Right? And this is important because if you say that you are bound or you decide to be bound by the expert determinist findings, then who is liable eventually? Of course, if you say that you are bound, it's like, I'm not going to be liable. So all that has to be made clear between the parties on the consequences of the findings. Or if it's just to take it into account in your assessment, you have to make that clear as well. Right? And for the assistance rendered to the expert determiner, what extent? One, are you willing to provide? What's the scope? Right? And timeline as well. Because they have to decide within 2 months. So it means that if they need some information from you, it has to be done expeditiously. Right? So you have to take that into account as well. Okay? So that you are very realistic about what is expected of you as the architect. Okay? And in closing, and I'll end with what I started earlier. Disputes are inevitable, especially when you're wearing so many hats and dealing with so many parties. But escalation is not. Escalation is always an option. So it's always advisable to adopt some preventive measures into every project. At least you have tried your part, you have done your part. And if matter still goes to court, well, what do you do? But at least you've done what you can. Okay. Thank you very much. And just to show you some photos, this is the expert determination workshop 2023 was done 2 years ago, and we hope to organize many more to grow the panel of experts for you to choose from and for parties to choose from. Okay, thank you.
Right, thank you. Interesting discussions on recommendations. I think first thing you look at from Annie's presentation, these disputes are generally very fact sensitive. Right? There's no two cases that are the same. Arguably, they are liability of architect very much better match the case. Entire project, right? I think maybe before we start, there is you say, yeah, the goal is to be case, to solve it. The reality is this: people going away, we make things that need to change the mindset. It's true, very ego driven. We want to throw it wrong. Point out that we made a mistake. That's the reality. I think you will change mindset from not ego driven, trying to solve it. Just following up that, the second is interestingly is expert determination. Right? That's under the act. But the question is, what happens to the architect doesn't agree the expert determination? And also, why would a party agree to expert determination? Really, the mind would say, okay, we open the application.
So one very good thing about expert determination is that the architect might disagree, but if parties agree to conduct themselves accordingly, depending on the finding of the expert determination, then it can proceed as well. Right? Because it's between the parties, and this can be especially effective when perhaps the issues are more between the parties and not with the architect. But what I mentioned earlier is that you, as the architect, have front row seat, and if you can do something about it to help mediate the matter between parties, then good. But if you disagree, if perhaps you say, no, I want to have nothing to do with this, parties can still proceed to agree to expert determination. But I think if there is no incentive for it, if the architect says no and the relationship is already quite shaky, then chances are parties might not consider that approach at all. And what Justice Anand asked earlier, why go with it when you can just reopen it in arbitration proceedings later on? It's just a temporary finality. So something like that you get paid first, any problems, then you go for arbitration later on. So at least there is some certainty on that technical dispute. So at least parties can rely on it for the completion of the project. Because most of the time, these things are happening as and when the project is still ongoing. So you need some certainty to arrange your affairs accordingly. This helps at least to give you some decision by an independent technical expert. So at least parties know, okay, it's not just taking a coin, it's based on some expertise.
I think that word temporary finality. Again, so these SIPA cases are very oxymoron. Okay, so kind of monitor, I had the opportunity of having to ask the second question before I was actually, you spoke a lot about defect, definitions of defect, etc. But when there's an defect, how does one actually reasonably and fairly distinguish whether such a defect arises from design, workmanship, or maintenance, and who actually decides?
I get asked the question all the time. I think it depends on the nature of parties in dispute. Just take, for example, the simple one, where, say, the swimming pool is leaking, and this happens, 2 years, 3 years after the BLP is completed. And then so what happens is that the action is taken against the on waterproofing warranties. So somebody is offered the waterproofing warranty. But then the waterproofing warranty guy says, look, but I'm applying the waterproofing warranty, my waterproofing on a concrete that wasn't constructed properly. he managed to prove that. So then it becomes a situation where is it in the fault of the waterproofing or is it in the fault of another issue that caused it to fail? So I think in every defect, it's very dynamic because all the components that get put together are so varied. So I think that's the first part that's very difficult. And if the information is not available, like some projects 10 years old, all the documents are lost, it's very difficult to establish. But commonly, if documents are available, how I as an expert normally do it is that I would first and foremost rely on contract specification. It means what has been drawn, what has been written. And those are available, it's very easy. That means, okay, I just benchmark it. If it says product A and this A, but when I looked at the site, it's B, it's very clear. But if that's not available, then the situation becomes a second priority. Then it would be a situation where then I may then decide based on my experience. So there's a descending kind of filter the way I look at it. And in between, I may also be referring to industry standards if those documents are not. So I think that has been the adage where I try to put my opinion at the very end, where there's no other available information, then I will only render my opinion.
Thank you. One last question for really about cases. We just find maybe a bit of limitation. How long? And more importantly, especially this where the after DLP. So you need to register the space. So much room. There's a time frame
I thought I was going to escape you. I thought I was going to escape your questioning. In latent defects, normally upon discovery, your time starts to run. So it will go beyond your DLP. As long as they can establish that it is a latent defect, it goes beyond the defect liability period, but that's when the time starts to run. So you cannot just rely on DLP and say once it expires, I've escaped liability. So that
Alright, thank you.
So that it's good. Yeah, it's not a very happy.
How safety should be there is a something pop up. What's the progress of experience what's the case of disease? It's covered 8 years, 12 years.
I would say 10 years would be a kind of yardstick. Why 10 years? That's generally the kind of lifespan of most of the materials that will require the life cycle. That means windows and doors and But one thing that I want to qualify here is that in the 10 years, often people say they equate it to warranty. Okay, we have 10 years warranty, 5 years warranty, this is the broad figures. But warranty is not service life.
Well, I have quite a years ago. After 8 years, all the tiles are because the asset is you after 10 years or 8 years, then they pop up. So I think this is changing itself. That's a big effect on this.
Yeah, that's often the situation where several years later, these things pop up. We've had many inquiries and cases that we had to do that. That's when you need to do forensic investigations. You need to be able to get the materials and be able to see the kind of nature of that fault. Remember the picture that I showed you all earlier, where the tile, you can see the imprint, right? So really there's no bonding at all. And that kind of situation can be argued as something that is latent. And it was just waiting for it to happen over time.
I think that the other thing is that although it may be limited, the one thing that will determine whether the architect or the party that installed this thing to be liable is whether or not when it was done in the previous consignment produced, whether it complied with the regulations, the standards of the practice, because it has changed. Pipes are one of them. Yeah, pipes is a big problem, but if you look at the pipes itself, at the time when most of the pipes, we call them pipes, are installed, they were accepted in the industry. But now we see problems arising. So if that happens, then how do you account for liability on an architect or business provider? Because when they did that, when they approved it, it met the requirements of the standards of the profession, what was expected. So how can we understand liability?
So it's to judge the liability matter. Now,
Absolutely.
judgment quality now is acceptable. And it's like, yeah, very mistake, like, please not be all right.
Yes, it is, absolutely.
All right, I think I want to be fair. I think any questions, please feel to raise it. Yes, answer. Anyway, no questions. I always say, I have two things. What nobody understood the game, no? I am extremely good. So.
My name is Lo. I have a question. For architects, usually our responsibility lies as long as the building stand, okay, as a PSB. How about the developer? Usually when they register their company under Sdn Bhd, and just now we mentioned, we look at the slide, the developer is have a duty of care to the MC. But what if after maybe a few years they wind up the company? So what will happen? Would that fall back to the consultants? Thank you.
I can tell you now, today, a lot of companies are hot up. Right? Very easy. I had a case, developer sold a startup actor, two properties to Mr. A. Mr. A paid. He never transfer the property, right? Because most of them came out. Then sell again to Mr. B. Then sell to Mr. C. Right? Then the developer wound up. A, B, C all fighting in court. I want that. Very difficult. One person. Developer tell me, wound up. It's tough. So sometimes companies are wound up very conveniently, but still liability. Of course, there are provisions in the company Act where those are more and more in trading cases where company is run with the view of defrauding creditors or clients, then the act is responsible. It's a very high threshold. Many of these cases where we try and cannot get against the company, file a proof of debt, can't get anything. It didn't show nothing much to do. Then the court will right. Right. Company we wound up is a huge problem.
I think in the case that Dr. Lo was my client, and the first thing struck us was that how do you advance a case of late delivery against architects? I never entered into a contract with you to deliver within 24 months. My duty is confined to ensuring that when I certify the building that it is proper, you can use it, it must be safe. It must meet the standards of the industry. And so in answer to Dr. Lo's question, if the developer is wound up, any liability that will be imposed on the architect can only be if you constructed a building that is inhabitable, it doesn't meet the standards. But it can never impose or extend liability that you fail to get your property on time, you want to get your monetary damages, then that can never be the case. So it's just unfortunate that in this case, the 15 purchasers, they ended up with nothing. They paid money, it was constructed, but they couldn't use it because the developer went bloody up. So that's why they tried their luck to extend that against that people, hoping that architects are rich, they can pay me, they got insurance, they pay me, so I'll go for that. That was the case that was their line of thinking because they have no other remedy.
Can I ask you that case?
Yeah.
Yes. See the basic that said that all the way from contract. Sure, the contract.
No, that case is the one Tanjung case that I was not a counsel. Yeah, that was the one Tanjung case because one Tanjung case was very interesting because they found the court led by Justice Hashim. He found that the liability should have been the local authority because they certified it. If we extend the principle to you guys today, then you will be the one who is because you signed the CCC.
Any other questions? Yes. I'm getting it straight. Okay. So my question is, okay, I say this now.
Your name and your position.
I got it. Manufacturing I got. Yeah, right. Feng Shui then already.
But you can't come to the romantic corner.
Okay, my question is now, people like to collect our rent. So, as you know, last day, most of the tender document that there's some cost intelligence, US, or project manager like and or any contract. Then we as a contract administrator, once the contract awarded, then we have to face the problem. So, my question is, why this happen? We as architect, we have the right not to accept an amendment to that contract under any law or under any regulation. We have the right to do this. Is any, if this happen, we must have the right to molestation.
Well, he gets molested. Over the break, Judge and Kenny was asking me, what is this parang? So they were googling the word parang. Actually, the parang contract was a term that I came up with when I was giving range talks earlier on about one-sided contracts and how it has been molested to the point that it's only favoring one side. Normally, the person who's going to be the employer, normally is the employer. I showed you two samples, right, up there. One was the one in Thailand, and one was the one in AI. Both of which I was the main contractor. Now, I don't have a choice so much as a main contractor to make changes to the contract because it has already been given to me and I have to comply to those situations. But as the architect, especially in Malaysia, and if you're running a housing project, for example, look, why on earth would you not just say, look, you will not accept this contract that's in the tender? You have every right to do that because you are named in that. So why would you accept being named as the CA or the SO you want to call it, when the conditions in there are not what your own institute has recommended you to do? And it has taken us a lot of very smart people, from Jisoo Teng and all these people who have spent decades refining the PAM Form. And yet the PAM Form is, to me, in my opinion, one of the most one-sided contract anyway. But at least for the architects who are familiar with it, and and the industry is familiar with it. But today I see a lot of QSs, what they do is that, because they're hired and they're doing all the contract documentation, red flag number one, when you got the QSs driving the contract, red flag number one, right? You just come in, you show up. So that's when, as an architect, you need to take back that position. Okay, number two is that many of the amendments are not done properly. They don't tell you exactly where they made the changes. They give you another page to say change from if to remove the word if, is no longer or, is now and. So they make little changes like that in fact change the
contract should have been drafted.
From a legal perspective, I think we have tried so far as courts are concerned to bring in a concept of unconscionability, right? It's difficult to balance because on the one hand you have parties who know what you're signing, especially in banking contracts. You know, the guy takes a $20 million loan, then before they come to the court, say, all right, you have to tell me what the contract was about, and you know the terms, right? Or the bank, you know, more powerful, I have no choice but to beat this contract. Tough lah, it's a kind of like the industrial money is like a bomb way. Sometimes you find, only unconscionable maybe, but I like to put it as unfair contract. The term is the contract is very unfair. The court can strike it down. Here we can't. Here the really, so I think the really, the desperate for a job, no choice that to sign. That's what that's the way.
So it's a business out there. You guys are both architects and businessmen. You know, you heard Kenny saying certain situations walk away. But to me, if more of you walk away and more of you stand firm about not doing the molested contract, I think it will reduce the amount of very glaring anxiety that me, like a main contractor myself, I have to contend with that. The moment I sign into a one-sided contract, day one for me as a main contractor, I'm going to be looking at making sure I balance the playing field in any way that I can. The moment you make one little mistake, I'm going to pick at you. I mean, at the architect or whoever. Because it is already not a loaded gun.
Right. That's the question. Any other questions?
Very good question.
One question. Actually, for PAM contract, we have a developer, we have a contractor, also the administrator, the consultants. What happened to the material supply? I think there's a missing link somewhere. For example, a project which has been material being installed and they are not paid by the contractor. How are they going to claim from the contractor or even from the employer? You cannot dismantle something which the developer may have paid the contractor, but the material supplier didn't get the payment.
I think it's straightforward. The material supplier, depending who is the person who I engage them. Most material suppliers, unless your contract says nominated suppliers, then you roughly know who they are. And most of the suppliers are under the main contractor in the architect's BQs and so forth. So if the supplier doesn't get paid, then the supplier has his own recourse through SIPA as well anyway to recover that money. And if the main contractor says I didn't get paid, he can also, the material supplier can actually move one step up to the employer, okay, in some sections of the SIPA. So I think this 1 year SIPA has covered this section.
About SIPA, I think this issue with it's actually more than what is previously compared. When you see, I'm in an interesting case for now, where the employer had a main contract, right, the contractor, and then the building came up after about the building, and 1344, they did a test, and they found a Q test, and apparently the building structure was bad, the cement was terrible quality. So they tear out the whole building after 14 floors. So the employer sued the main contractor for 80 million, right, for the cost of it, to demolish the whole building and build the building again. But the employer is saying, the main contractor is saying, no, not my problem. The fellow gave me the cement, gave me some lousy cement. Alright? Yes, so why is that? So the employer comes to the subcontractor, there's no contract. So in civil proceedings, you can actually have what you call third party proceedings. The defendant may then bring another party in as third party, cover any indemnity or contribution that is found. So in civil cases, that case, actually two parallels to wait. So I have the employer suing the contractor is brought in the cement supplier, third party. So the trial goes up, so first trial comes to the main party and the defendant. If they find that the cement was not effective, then end of the day, the painting loses the entire case. But then if I find that there is defect, of course, not down to the experts. If I find that it was actually substandard cement, as called them, then the question whether cement supply actually came from the cement, without mixing it back and whatever. Then of course, the is higher. If the cement given was poor quality in the first place, then the cement supply will be hot. Which you can so that's how it works in civil games. Very, very good idea. I think we have this is so we have those sort of cases. Why can I have a simple case? So you can, but when the employer comes to the buy directly, but there are other ways. Yes.
Yeah, the corner, a lot of problems.
Sorry for that. I just wonder, do local authorities still hold any responsibility when it comes to resolving any technical dispute? Because previously the OC was issued by them, but now all the CCCs are by us. So I wonder what local authorities hold.
Well, it was a very interesting point posed because when we did the SCI, it came to a point where the panel led by Dato' Yo just said, so you are actually here just to rubber stamp this, because they literally says that everything is pushed to the consultants. So the question that we posed at that point was that you have your own building department, you have your own engineering department. Surely you are the final arbiter as to whether, and so you should take responsibility. But that's the position they took. And they hold you very closely to the words that when you sign on your building contract, the words I brought up just now, when you say Sayang and Nasaka. And that's very unfortunate, but that's the way it is. And so when, I think it was Irwin that came and we cross-examined him, 20 lawyers actually cross-examined him. He basically referred us, because that was the case that their lawyers for the council fashioned for that. It's not my problem, guys, it's your problem. Then it becomes a problem between, is it the engineer or is it the architect? And so everybody is fighting for survival. And the only thing that saved our neck was the fact that we didn't assume responsibility, because we made it very clear in the contracts that that's not my area of expertise. And we relied on those that I referred to. But it was basically a fight between the architect and the engineer to absorb liability. Council just said, hey, it's not my problem.
I add something, Judge. Architects, the right-hand corner of your building plans, what do you write before your signature? Saya mengambil tanggung jawab for all the, then you put what, UBBL, right? And the UBBL in there has got what, engineering also there. So, kind of like, from when I saw Kenny slides just now about not demarcating clearly between your scope and the engineer's scope, and making that broad declaration that you mengakui UBBL, which sections of the UBBL? You get what I'm trying to say? See, if somebody is a little bit, you get a name like a lawyer, like, I don't want to call them names, like, and they start creating ways to just push it to the architect, you're going to get drawn in anyway. So just be mindful about that. Maybe something the working group needs to think of. Sorry, for the first one, couldn't quite sit the variation order, yes.
sure that you get, especially if it's within his purview, make sure you discuss with him first on the consequences of the finding. If not, parties will be wasting costs for nothing. Because if he doesn't agree, and if he doesn't want to take it into account when he makes his own assessment, then everything's for naught. So, in that sense, he has to be in agreement as well on what he wants to do. Your second question, the PCWD, can't answer that question because while we are all still waiting here, David and Dr. Tan are waiting to meet the minister. So I can't answer that. At this moment, we are writing to the minister to say all of this uncertainty with this new regulation. So just hold on first, and meanwhile, don't sign anything to agree to the PCWD. Okay, just hold the handbrake. We already have the Bhad's backing. Just don't agree to anything. And if the developer insists that you agree, write it to say you're no. And if you really get into trouble, then contact us. Okay? Sorry, Judge. One more question on the expert determination thing. Honestly, we don't know all the mechanisms yet because we haven't started. All it is that PAM has just, the expert determination clause has been in the PAM form for a long time. We never had the rules and we didn't have the procedures. So over the last 6 months to 8 months, we tried to put out the rules. Again, even in the last council meeting, one of the past presidents of council said, I don't agree with expert determination when there is a disagreement about EOT, for example. And they say, I have already granted EOT, but the contractor disagreed. So how can the parties go to expert determination? So expert determination ought not to cover EOT. So then again, how do you choose what is going to be determined and what is not? That's why I think the position that so far Daniel has been working with our consultants who are drafting our expert determination is to say if parties agree themselves that they want the expert determiner to do, but the architect needs to also decide the position that he has to take. If not, it won't happen. I don't think expert determination will then happen if the architect says outright no. But if parties agree and the architects didn't agree, I really don't know where that takes us to. Judge, I don't really know.
About this CWD, even PCWD, I think based on the recent seminar we have with DOF people, they say that temporarily they are not taking any action. But the problem is CDM 2024 has been enforced. So what if within this period anything happened? Because according to them, it's quite ambiguous. We were talking about foreseeable, but how to foreseeable some things to happen?
I think this not
Even those people were talking about.
Although I think we don't dive into this because we already had a session. We wait for our engagement with the minister. We can't contemplate something that might or may not happen.
That's how you practically answer the question.
I want to chow already.
Yes. Okay, so thank you for all.
Yeah, can I have a round of applause for three panelists?
Also, take the opportunity on behalf of PAM of Contractor to also thank the judge for taking your time to come here. It's a real privilege for all of us. And I also say that for us to get a judge to come here, we had to actually write to CJ. And we wrote to CJ, of course she's no longer there now, she's retired. It only took CJ's office a few hours to approve it. I think we wrote in the morning, by the evening we got it. So I think they they really want you to come